Good morning, BIA Nation. It's Michael McSweeney welcoming you to this webinar. For those of you that don't know me, I'm the Senior Public Policy Advisor at the BIA. Senior because I'm old, notice the gray hair and the COVID face beard. I wanted to introduce our panelists today. We've got a couple of our friends from the Regional Water Quality Control Board. They are the local permitting authority for anything that has to do with water, whether it's drinking water, stormwater, wastewater, somehow they touch it. And we have Dave Gibson, who's the executive director, and Eric Becker, who is the senior water resource engineer that handles the 401, 404 certifications. That's his responsibility. And the intent today was to put you in direct contact with the people that make that enforce the rules. They're tasked by both the state and the federal government with enforcement of the Clean Water Act and locally the Porter-Cologne Water Act at the state level, which touches on the 401, 404 certifications and permits. So they're gonna have a quick presentation and we hope to have most of the webinar open for your questions. The intent here is for you to understand what goes on in their shop so that when you bring your projects to them, they're set up so that hopefully you can get through their process as quickly as possible. We all know time is money. So without further ado, welcome to Dave Gibson and to Eric Becker.
Thank you, Mike. Thank you, everyone. We have a short presentation. I'm going to start it off and then turn it over to Eric, and I believe I'll be running the presentation. And we've tried to leave as much time as possible at the end for questions and discussion and for dialogue. There's several things I think to start off with to frame all of this. I think that most everyone participating probably is aware that in California, at least about 95% of our wetlands area, freshwater marsh, saltwater marsh, ephemeral drainages, have been converted to other uses, feeding us and housing us for among others. But that has focused attention on trying to manage the remaining 5% or so, depending on how you count them. And so since the late 1980s, there have been two executive orders on the books, one from President George Herbert Walker Bush, one from Governor Pete Wilson. Basically, both of them are a no net loss of wetlands executive orders. And since the mid 1990s, the Water Board has been implementing wetland protections, at least through Clean Water Act Section 401 in accordance with Army Corps of Engineers, who administers Clean Water Act Section 404. Whenever you need to have a federal permit, you need to get one or both of those from the Water Board and from the Army Corps. And then there are state authorities as well that I'll talk about. But in the context of wetlands, executing those authorities, it's not simply a question of issuing permits as quickly as practicable, although there's certainly that point of view. It is trying to get the most we can out of protecting wetlands. And so 7 years ago, the Water Board adopted its practical vision, its strategic plan. And this year in December, it's pending for reissuance and renewal. And chapter 3 of that is restoring and maintaining and protecting wetlands and stream systems. And the board came out of that with a lofty goal of trying to not simply achieve no net loss, but actually a meaningful net gain, whatever that should mean. I cannot say that we have achieved that in 7 years. We have several projects we've been working on, and restoration projects or mitigation projects take many years to reach fruition. And we have not yet seen the dial turn back on that 95% recovering or expanding upon those wetlands. And we are also now faced with climate change, which is going to change our ability meaning our ecosystem's ability to have wetlands. We're going to have longer dry periods punctuated by very intense atmospheric river storm events. What does that mean for our future? We're already beginning to look at that in terms of how we regulate activities, which we'll be talking about for the rest of our time, in terms of protecting wetlands through avoidance, through minimization, and through mitigation efforts. So now I'm going to attempt to share my screen and run that presentation. Please bear with me if I screw it up. Wouldn't be the first time. So what is a Section 401 certification? This comes from the Clean Water Act, and it's a state certification of a federal permit, like the language says on the screen. In this case, the federal permit is an Army Corps 404 permit. And it certifies, and there's a long statement that I'm asked to sign for each project, that the proposed project will not adversely impact water quality standards. Water Quality Standards 101 is the numeric or narrative criteria, for example, copper concentration or a nutrient concentration, the beneficial uses that those objectives are intended to protect, and the anti-degradation policy. So for any water body in the region, you can go to it in our basin plan, say Los Penasquitos Creek. You will find the creek identified as a water of the state and waters of the United States. You'll find that it has a number of multiple beneficial uses, including recreation, and you'll find water quality objectives and criteria that are intended to protect that recreational beneficial use. There are others. That certification is, I am certifying on behalf of the board, or the board is certifying in its action, that the proposed project will not affect those water quality objectives, will not affect the attainment of those beneficial uses. A very, very powerful and important statement. There are two different arenas in which the water board protects water quality and beneficial uses, and there's how it regulates activities on wetlands. There's the federal side on the left-hand side of the screen, and there's the state side. You may notice that there's a fair amount of overlap because the Port of Cologne Water Quality Control Act preceded the Clean Water Act, and the other on that went to work on the Clean Water Act. The language is somewhat different, but many of the instruments are the same, and they have mirrors. There's a section 401, 404 in the Clean Water Act. The state Port of Cologne has multiple sections in which the water board regulates discharge of waste to waters of the state. In the Clean Act, it's referred to dredge or fill of waters of the United States. In the state law, it's discharges of waste, which can include sediment and fill to waters of the state. In the Clean Water Act, we can certify or we can deny a project, and we'll talk more about that. In the water board arena, we issue waste discharge requirements or waivers of waste discharge requirements. Under the Clean Water Act, I get to decide for the water board. Under the state law, the water board gets to decide, and I hopefully get to make a recommendation. We are able to enforce this under the federal permit for 401s and under Clean Water and under California Water Code sections 13350 and 13385 under state law. There is broad overlap in our region, and we're unique somewhat in the state and in the country in terms of how much overlap there is between what are federal waters, waters of the United States, and what are state waters, waters of the state. And even changes at the Supreme Court and changes in regulation that are in place or pending now have not necessarily changed that as much as you might think. There are more waters of the state than there are waters of the United States, but all waters of the United States are waters of the state. And examples of the isolated waters or state waters are vernal pools, agricultural ditches, and probably now in the future, ephemeral streams, although Eric may have some more information to share with you on that. The state of California has been assiduous in as much as every time the federal jurisdiction has been changed or shrunk, state jurisdiction has been functionally expanded to include those same activities. So when the Swank decision removed isolated waters like vernal pools, the California Water Code was basically reviewed, and our state administrative authority exercised to protect those waters through waivers of waste discharge requirements or waste discharge requirements. So Eric, I believe I'm going to turn it over to you from this point on, and be happy to advance the slides as you indicate.
Sure, thanks, Dave. Good morning, everybody. My name is Eric Becker. I'm the senior engineer with the San Diego Water Board, and we handle the permitting both 401 and waste discharge requirements for discharges of dredge and fill to waters of the U.S. and or state. This is just an example of what we do regulate, and I'll kind of get back to it later on when I come in some of the other topics. But it's an ephemeral drainage in Valley Center, and there's not a lot of field indicators that it is the waters. But there's some giant culverts, so obviously a lot of water goes through that. So we'll revisit that photo here in a little bit. So Dave, if you want to go on the next thing. We've had a lot of changes on the federal level, but ultimately the structure of the permitting structure hasn't changed. We get an application and we have 30 days to figure out whether you're gonna go do different roads here. One if it's complete and one if it's incomplete. If the application is complete, then we have 60 days to take an action, whether it's certify the project or issue a denial. If a project is incomplete, we identify the deficiencies in the application in a usually lengthy letter explaining what we need as far as to move the project forward. This has changed a little bit under the new regs. This whole time frame, we have to act within that 365 days or less. Otherwise, the Army Corps engineer could consider the application waived. And so we will ensure an action within that 365 days. So part of the problem, or one of the issues, or the roadblocks or speed bumps you want to is when the application is incomplete and we're asking for additional information so we can move the project forward. So I'm going to kind of hit it on areas here where we can actually maybe smooth out the process and also shorten it for both the applicants and the water board staff, because I think we're all in support of making the process faster and easier for everybody. So the first thing to use to help out would be to follow the new wetland procedures manual. State board worked a lot of years and put a lot of effort in establishing this procedures manual for wetland waters of the state. It provides a wetland definition. It gives a framework in determining what meets the wetland definition of the state, and provides delineation procedures. It also includes procedures for determining going through your submittal, review, and approval for both the 401 and the waste discharge requirements. It also includes different new provisions like an alternatives analysis. So they just developed a checklist that will help you figure out what is required for a complete application under this procedures, and it's online, so I encourage you to go ahead and use that. Not yet, Dave. Next thing, and I can't emphasize this enough to help speed up the process, is the pre-application meetings. It's really an opportunity, and key opportunity, to provide non-binding feedback to you. The new regulations actually require that you formally request 30 days prior to applying a 401 for a pre-application meeting. But there are informal options available still. You can contact us directly. It doesn't start the clock. We would be happy to meet, and we have been doing a lot of pre-application meetings informally with applicants, and it's been successful. Also, the California Department of Fish and Wildlife offers a pre-application meeting second Tuesday of every month, and you can contact them and get them on the agenda. And that has the benefit of having all the agencies there and providing immediate feedback in an informal process. So this pre-application meeting is great. You can come in and talk to us about impacts. If you have questions, I mean, like that picture shows, there's questions. What is waters of the state? It's kind of all encompassing. So if you have questions on, do I have waters of the state only on my property? This is the time to ask us. We can give you feedback. You may not necessarily like the feedback, but at least you get it early in the process so you can make some decisions. Also, you run by mitigation proposal with us, and it's non-binding. And here's what we're thinking about. If it's not going to meet our needs or we have issues, we're going to let you know that. So I think you prefer having that knowledge up front before you apply, and having to go back and forth and giving you comments. Okay, Dave, you can go on the next one. Next thing is providing clear and accurate information in the application. So what does that mean? Well, first stop is avoiding these kind of simple mistakes or relatively common mistakes. My staff provided this as part of our workshop last year, but we get a lot of incorrect forms or missing technical documents, like not having a mitigation plan. They're just cutting and pasting CEQA documentation into the application, and there's actually missing parts of the application. So that's going to cause delays, because we're going to send it back or ask you to provide supplemental information, and that takes time. So if you can just note these things and make sure that your application doesn't have these common mistakes. We also want you to clearly describe the project. What is the project and what are the impacts? We really need to know. If you don't know what the final project is going to look like, maybe it's not time to apply yet. We also want you to... Oh, go ahead, Dave.
I could jump in. One of the examples of that, I think it's really relevant for this audience, Eric, is a project which I actually issued a denial because the project was inadequately described, and inadequately describing, they didn't explain all of the avoidance steps they'd already taken to minimize the impact of the project. So they actually did themselves a disservice by not summarizing what was probably maybe more than 10 years work with the local agency to shape the project. And so in the end, it got denied. And so really being forthcoming and transparent about the complete nature of the project, the history of it, the development of it, is mostly going to work in your favor. So you should definitely make sure the project proposal is well fleshed out, and your consultants can help you do that. Thank you, Eric, for letting me jump in.
Oh, no, that's a good point. And in fact, that project Dave's referring to had a lot of avoidance and minimization, and they just didn't convey that. So they were denied unnecessarily, essentially, because they didn't provide the information.
So if I could
Yeah,
jump in for a second. So, you know, a lot of times developers will try to envision a project and do due diligence. They just don't go out and just buy land and then say, oh, what can we do with it? So would it behoove them to come and see you if they're, you know, in a formalization project? Because typically they tie up a piece of land through some sort of an option that gets renewed, so they're paying on it. But they may not have a project specific in mind, but may have a general idea. Do you still want them to come in and talk to you so that they can get a feel for what they would have to do?
Yes, and I've asked that, offered that. I mean, if they haven't bought the property, I think they would like to know what the resources are and maybe what potentially the mitigation or avoidance measures they'd have to do if they purchase the property. Yeah, it doesn't hurt. I mean, I'll spend an hour with them going over if they have a site map, or we can explain what, yeah, we probably take restriction, or we wouldn't. You want to consider that if you purchase that property, and what's the viability of your project if you have to do all this mitigation. So.
Thank you.
Sure. Just the last thing on the accurate application, please provide don't mix the agency impacts. We tend to get lumped into fish and wildlife as state waters. It would really help us and staff if we knew exactly what the regional board jurisdictions are and quantify in acreage and linear feet. If you have questions on what that is, talk to staff about it, or me. Next section that would help is having an avoidance and minimization section in your application. It's required. It's got to be included. It's not a construction BMP plan. We get that a lot, though I like construction BMPs. It's not appropriate for this area. And quantify, really, if you are able, sometimes not able. I get that your site plan you can't avoid and minimize, but you need to provide the process, demonstrate the process you've gone through the process and considered it. And then we'll take a look at that. And then if you are able to quantify those, it's a good thing. You can present that in your application. Hey, we avoided and minimized this many acres, which helps on the back end when we develop your mitigation plan. We've had projects where they've been able to avoid most impacts, and they were able to just go directly to the bank for those last few impacts that they actually had to do. So that is helpful. On to another thing would be having an adequate mitigation plan. If you want to move on to the next, this is the answers to the test. So provided this in our workshop last year. So these are our preferences. We can't say this is what we require. So it spells it out pretty clearly. Obviously, there's some site-specific changes that differences that we might come up with. Different types of vernal pools may require a little less mitigation. But in general, this is a good rule of thumb when you're developing your plan. So you know what the answers are. You can come in and talk to us before you apply. So really, if you do have a mitigation plan, it should be pretty seamless once you apply. Okay, yeah, get it pre-approved, come in, talk to us about it and concept. It can change. Again, once you apply, it can't change. We're gonna have to do the formal review and comment process. Separate out all the mitigation that's for different agencies, that's helpful. Talk about acreage and linear impacts. We don't necessarily require, linear impacts for mitigation for linear impacts, but we are looking for whatever your mitigation is contiguous and provides a functional lift. So that's what we're looking for. And then also just to note that we don't require mitigation for temporary impacts typically. And by temporary, we mean anything that can't be restored within a year of impact. So, all right, next slide, Dave, please. CEQA, drafted is okay when you apply, but we do need a final CEQA document before we issue. This is important. We had an example of a project that came in. They did great. They did the pre-application meeting. They avoided and minimized. They had a good mitigation plan, and we probably could have certified the project within 90 days, but they didn't have CEQA. So they got denied. And so if your CEQA is over a year out for final documentation, we recommend you not submitting because we're going to have to deny the project. And once we do deny projects, they kind of go back in the bottom of our queue because we're moving on to other applicants. So think about that before and make sure that you know when you're, and I know sometimes you're not in control of how the CEQA gets developed and scheduled, but if your best case, anything under a year, we can have no problem applying, but if it's over a year, consider holding off that application process.
And it's probably worth pointing out at this point that there are two types of denials that we can issue. Denial without prejudice is basically a pause on the project. And in the case that Eric described, everything was ready to go, but without a final CEQA, we can't act. And so in that case, we denied without prejudice until the CEQA was completed. A hard denial, on the other hand, basically ends the project, and they have to come back with a whole new project or a very different project later on. We don't do a lot of hard denials. We have done some. And I did some math a few years ago and looked back at about a 10-year period, and we issued certifications for about 98% of the applications we received. Some of the 2% that weren't certified were withdrawals. The project terminated, the people moved on to something else, did something else, or avoided so well that they had no longer a need for a 401, 404 permit. That's also a good outcome. But some of those were also hard denials. And so we do issue denials, but we also issue mainly on the whole denials without prejudice as administrative pauses until something that was critical for the application is received. CEQA is a good example. So again, pre-application meetings can be very helpful in terms of timing because getting an application in early doesn't necessarily mean you're going to have an action earlier if one of the key elements like CEQA is outstanding.
So Dave and Eric, so you're trying to make, in a perfect world, be on parallel tracks with your CEQA and your 401, 404.
Yeah, that would be perfect. I mean, again, we can't issue and then we'll have to deny because we can't issue the certification. So,
right. And when you have the pause type of denial, so let's say, you know, the project that didn't have CEQA, they got everything done, everything was looking good, they had the pause denial. Then when they get their CEQA done, are they then starting at the bottom of the queue again?
They could. It depends on the projects we come in. That's the problem when you get a project denied. We'd rather have them hold off. And if we can certify it quickly, and I think I would recommend that if we do have projects that are ready to go, that we can make them, you know, at the top of the list. If we can certify them, everything's great. But yeah, if you do get denied, you tend to be, because we have to move on to other projects that we can certify. So
okay,
if a project is denied, usually it's put down. Now, I think on the new regs, actually all projects are denied without prejudice, but it's just a denial. So the only difference with denial without prejudice is that the fees kind of carry for about 12 months. So the fees don't expire, but really denial is denial, whether you can use the fees for 12 months or not. It's still a denial, and they still go to the kind of bottom of our list.
Okay.
All right. And the last thing here is just communication with my staff helps, and then we'll get some questions. Please respond to any incomplete or complete letters quickly. Sometimes there's a lag of months, years, and then we have to move on to other projects. So, and please contact staff directly. I know they're busy, but they are supposed to respond to you within several days, especially with the email. Maybe give them a little grace with the current situation. But if they aren't contacting you back, you can always contact me, and we can make sure that happens, because we do want to foster the communication, because writing letters back and forth is not helpful. But we do need if we write an official letter, we'll need an official response back, either through email or a letter, and responding everything that we brought up in that letter for the record. But contact staff, talk to them frequently, and ask for meetings. We've been doing a lot of those. Obviously, we can do these online, and they've been very effective. And then just the last thing is field work. You know, we're still under stay-at-home order from the governor. We're not in our office. However, I know field work is important, and we can work with the applicants to come out to the sites. If you do have that request, just please either send it through me or include me if you're asking staff do some field verification. I think we can probably work within that. And that's all I have as far as now, but I'd be happy to answer questions.
Okay, let's get started on that. The first question is, what type of bird is in the picture there on questions?
It's a burrowing owl down by the border. And he was, I don't know if he or she was giving our staff the stink eye there while they're doing a field investigation. So.
Okay, so.
Not necessarily a wetland species, though.
No,
is it?
No, he was kind of cruising along the dirt road, but he was following one of my staff along the road. So want to make sure that they didn't get to their nest. So.
Right on.
But I love the picture.
So I wanted to remind the webinar participants, there's a chat box, but there's also the Q&A. So you want to put your questions in Q&A. So the first question that came in was when I had asked you the question, when requesting a meeting, when an applicant only has a concept, as recently discussed, would it behoove the potential applicant to come have a jurisdictional delineation completed in advance of that meeting?
Sure, that would be really helpful. I mean, but it's usually the delineation is more federal. So the question and the arguments, like our picture we had earlier in the presentation, is what is waters of the state and what's that jurisdiction? So yes, if anything you have before you come talk to us would be helpful, and then we can build upon that.
Okay, next one, regarding proposed mitigation for linear impacts to ephemeral features, can the no net loss criterion be met by creation, restoration of wetland waters in lieu of creating new ephemeral features?
Yes, and we've done that in the past where we have wetland, which is type it can be a different type. It doesn't have to be ephemeral for ephemeral necessarily, but we were looking for them to replace the functions and services that are lost by that ephemeral drainage.
And that's a topic to really discuss during the pre-application, especially because that can really shape a project and how the application comes into us and is handled. So any opportunity to look at those types of issues early on is always going to be much better for everyone.
All right, thank you for your presentation. Did you say there is no longer a required 1-to-1 mitigation ratio for linear footage?
It can be, I guess it depends, but if you can't meet the linear feet for 1-to-1, then we're looking for you to provide something that's equivalent to the functions and services. So with part of the procedures, it says you can either do acreage or linear feet. And so we're trying to work within that. I mean, linear feet, we've had in the past where you had 2,000 linear feet of really a small ephemeral drainage, and they did that. But it wasn't really effective. It was just kind of replacing it with something that doesn't provide the functions and services. So we're open to doing less than 1-to-1 on the linear feet, provided we get that function, that lift in functions and services. So
I know I've signed at least a couple of those where it wasn't 1-to-1 on linear feet.
And that, correct me if I'm wrong, but I remember one of the meetings we had with Jim Whalen where he described the zigzag back and forth. So it was basically the check the box, so many linear feet, so now you have so many linear feet, but it really didn't function like an ephemeral feature.
Correct. Yeah, we want effective. We don't just want just linear feet for linear feet's sake.
Okay, on the mitigation ratio side, did those ratios apply to both wetlands and non-wetland waters?
Yes, we treat both as important aquatic features, and we do require 1-to-1 for both ephemeral and wetland type features. 1-to-1 establishment, reestablishment. Now the ratios like the 3-to-1, they can include other types of mitigation to meet your 3-to-1, and typically that's been enhancement or other kind of. Do the 1-to-1 establishment, reestablishment, and then get additional 2-to-1 in other types of mitigation, which is okay.
All right. Can we concurrently process a 401 permit application with a local jurisdiction's design review process for a project that has a master EIR CEQA document that has already been adopted? If so, what happens if the city's requirements cause us to make changes to our proposed 401 mitigations or design?
I guess so do they have to come back and ask for an amendment? Is that the intent of the question? I'm not sure. We're going to rely on whatever final CEQA documentation is, and then we're going to issue the certification based off those impacts and mitigation. And our expectation is that the applicant will meet those. If the city requires more or something else, then they're still on the hook to meet our requirements.
All right, so the person that put that question forward said yes. So, and I just want to remind everybody, right now I'm in the chat box. I'm going out of the chat box to the Q&A. So put your questions in the Q&A area. And we have 11 questions there. First one, what happens if the CEQA is approved and then challenged? Can the 401 certification proceed? Is the 401 still valid if the court overturns the CEQA certification?
It's still valid pending, litigation. This happens to us all the time. So, and I don't know as far as if the court order, we'd have to talk to our attorneys whether or not if they have a final, court order and how that affects how we made a decision. So I can't answer the second part.
Well, that was from our favorite attorney, so
yeah.
You shouldn't be surprised. Okay, please confirm that both temporary and permanent impacts require mitigation, and also the fees would apply to both types of impacts as well.
No, mitigation is not required for temporary. And temporary, we define as anything that is a year or less, that they can't restore it within a year or less. So permanent impacts are the only thing that requires typically mitigation for. Now, sometimes like there's a massive amount of temporary impacts, we may consider requiring some type of mitigation, but typically we do not. And what was the other question? The question is the fees are based off of total impacts.
Okay. I believe it was mentioned the possibility of permits surpassing the 401 approval process. How would this be done to continue the development?
What type of permits are they talking? I mean,
it doesn't say.
Okay.
I also want to jump in here. I would think that anybody that's on this webinar today, if I asked your question and you didn't get the answer, or like Eric just said, what type of permit, his email address was right there underneath the owl. So you could shoot him an email and get your answer in a more detailed response. All right, we'll go to the next one. I have seen 2 projects now where staff has had concerns about species viability, which seem beyond the scope of water quality. So I guess what they're asking for is species viability. How does that all tie in?
Well, species viability is beneficial uses is what we are protecting, and water quality standards, and one species and helping species and vegetation is part of that beneficial use that we are protecting. So we would take that in consideration. So I don't know, I can't really speak to the specific project, so I'd have to have a little more detail on that to answer that.
Okay. Eric, you mentioned there is an opportunity to have a pre-app meeting with all the regulatory agencies at once. How is that accomplished?
And I can send this out. There's a contact, Kelly Fisher of the California Department of Fish and Wildlife sets these meetings up in the agenda. So you basically contact her and they can schedule get on the schedule for one, and again, second Tuesday of every month. And so a lot of applicants do this and they get some good feedback. So I can provide that later on if you want.
Great. We got a question. What does it mean in your slide, if out of watershed, add extra digits?
So we want in watershed, or if you're close to the impacts as possible. So the farther you get away from your impact in your watershed, requires additional mitigation. So kind of the rule of thumb is that if you're doing 1-to-1 and you're in watershed, but if you have to go over to the next watershed to do your mitigation, you add one. So it would be 2-to-1. So the farther you get away, the higher the ratio gets. So that's just a rule of thumb. It's not a mandate. So.
All right. Is the regional board's jurisdiction now extended to the top of the bank as opposed to the OHWM as in the past?
Well, yeah, the ordinary high water mark, OHI, is a federal standard. We often and most times our state waters is above that. Top of bank is a typical one that we have used in the past. But again, we're looking for, like I mentioned in my presentation, is we want to know what the flow of the water is through. What is the hydrology of the site? So we can make some determinations on that. But to answer the question, yes, we typically go top of bank, but that depends on the site.
If mitigating using a bank, does a portion of the credits need to be specified as creation, or would restoration and or reestablishment credits suffice for the no net loss requirement?
Most bank credits are establishment, reestablishment. So that at least the 1-to-1 portion of your mitigation has to be establishment, reestablishment. So I don't know if they have, the banks currently have anything other than that, so.
All right, this one I think would be for both of you. It may be in Dave's realm. With California's critical housing shortage not getting any better, have you experienced any pressures from the legislature or governor to think of balancing the environmental need with housing needs?
I would have to say not necessarily. I think the governor and the administration and Cal EPA are really quite concerned with the housing crisis, but the housing crisis doesn't turn upon wetland impacts. I would say they've been far more concerned about fire control, fire prevention. They have actually mandated that we put time on it immediately as soon as the applications come in, 2 projects for fuel breaks. That has gotten direct attention from the governor's office for obvious reasons. We're seeing them now. There are, I think, many opportunities to improve our housing situation that don't require wetlands impacts, redevelopment of existing areas, for example, infill. And where we do see impacts, those are usually not the kind of houses that really help with the lower to middle income housing buyer. They are usually higher end. The market drives the types of projects. Wherever we can, though, we are looking ahead at opportunities to work with developers, with municipalities, to create new housing opportunities. And so I've met with the city of Encinitas on a site that could be redeveloped that would provide substantial new housing. It doesn't require any wetlands impacts, but it is the type of project where other parts of our regulatory authority would come into play. So we are very sensitive to that. And where there are projects that could provide meaningful housing opportunities that do have meaningful impacts, those are going to be high on our list of priorities to address because of the concern we all share for the housing crisis.
All right. Does the Regional Water Quality Control Board require a typical year flow contribution analysis to determine if an ephemeral drainage is under their jurisdiction?
We typically require just modeling of the 2, 5, and 10-year storm for a site, and we use that information to come up with what we think is jurisdictional. But we are open to what is reasonable for the site, and because sometimes those are kind of overestimate the flow that's going through the site, so they want to maybe consider you're getting infiltration and other things. So, but we are open to coming up and determining what is the flow going through the site and what we're going to take jurisdiction over.
Okay, next one. Sometime in 2018 or 2019, the lateral extent of the waters of the state in non-wetland waters was changed from between the ordinary high water mark like Army Corps to between top of the bank like California Division of Fish and Wildlife. How do you justify expanding the jurisdiction without any official published or written policy change?
Well, I mean, if you look at the definition of waters of the state, it's pretty much wherever water flows. So we're trying to come up with a reasonable, what is waters of the state and implement that. So it's not a policy level decision. We're trying to decide what's appropriate, what's reasonable, and we're trying to work with the applicants and what we consider to be waters of the state.
Okay. If we have a 401 certification for a project impacting features that are no longer eligible for coverage under a 404, the project could proceed with just the 401 and does not need to go through a new WDR process?
If 404 does not apply, no, the answer would be we would have to issue waste discharge requirements. And that's unfortunate. So we are encourage applicants at least to get some portion of the site under a 404 permit. That makes Dave's life a lot easier. He can just issue the 401 certification. But if the Corps is not taking jurisdiction, not issuing a 404, we can't issue a 401. We'd have to go waste discharge requirements and all that entails, which requires us to take in front of the board.
And thank you for making my life easier, Eric. But that's really not the question, I think, for most of us. Yes, it is much more efficient for me to be able to act upon it under the authorities delegated by the board. If it has to be waste discharge requirements, there's one of several avenues. There's site-specific waste discharge requirements. They have to be scheduled before the board. And that isn't going to happen within just 30 days or 60 days. That we plan our board meetings 3 to 6 months out and longer. So it would have to fit in there. And that staff time is extra on top of what would ordinarily be encompassed in a 401 certification. The other avenue is a waiver of waste discharge, and we may need to identify more waivers in the future with the new jurisdictional rules coming from the federal government and the state board's new definition and policy. And the third is a programmatic waste discharge requirements in which parties enroll in a master permit. But all of those are going to, except for the waivers, are going to likely take more time, especially at the front end. So whenever it's practicable, look at your site and see if, does it in fact include federal jurisdiction? Get Army Corps to be on the record one way or the other, make it clear for you where your pathway lies, and we'll be able to eventually serve the public's needs for the project on one of the several state-based avenues. And if my life is easier, great. And if it's not, that's what I get paid for. But predictability of certification or approval is what we really want to provide the public in terms of what they have to do in order to get the certification to protect the waters, the water quality, and the beneficial uses that they support and that we enjoy.
I was probably thinking about my life making it easier, not yours. So
thank you.
Being selfish, sorry.
All right, next question. Is the value of the entire project the basis of the fees or the estimated cost of activity that impacts just the drainage?
It's just the actual impact, the acreage of the drainage that's being impacted, not the whole site.
Okay, there seems to be a little bit of confusion. That's why this next question is up. To confirm, is the pre-app meeting required at least 30 days prior to application submittal? And does the multi-agency meeting scheduled through California Division of Fish and Wildlife satisfy that requirement?
Second part is no. The new one, it's the new part of the new 401 regulations. So the applicant, if they're going to submit a 401 application, they have to request a pre-application meeting from us. They don't actually have to do one. They just have to put that formal request into us. And we're starting to get a few of those here. But the Fish and Game one is in an informal process. It doesn't start the application process and time frame, and it doesn't count towards that. And also meeting with us doesn't count towards the application time frame.
All right. In the last BIA presentation, 1-to-1 was presented as the minimum mitigation ratio for waters of the state. In what situation would 1-to-1 be accepted?
We've accepted it sometimes, just like if it's in watershed or it's on site, sometimes you can get insight and there's not a temporal loss. You may be able to get away with 1-to-1, at least establishment and reestablishment. It's never going to go below that as far as that. Now we may add, if there's going to be some temporal loss, you're doing some mitigation on site or in the watershed, and it's going to take some time to get that thing up and running, that we may require some additional mitigation like enhancement. So it's not the same type of mitigation. It's different. It's not as, I guess, as onerous. So.
Okay. Are mitigation credits available by replanting burned riparian areas with maintenance of the designated open space?
replanting is great. It's not going to go towards reestablishment or establishment. So
I think what somebody's looking at is we have a huge wildfire.
Yeah.
And let's say there's a whole area of a stream or a creek that's been burned right down to the water line. Would a developer be able to gain mitigation credits to go in and repair that riparian area and be able to generate credits for their project?
Yes, potentially. It's just not necessarily, it depends on the type. Again, it's not going to be establishment, reestablishment. Something that it wasn't there. You're repairing a system, and you could get some credit for it, which could be helpful. It's just not necessarily that, if that's what they're looking for.
It's worth looking at. Any good crisis offers some opportunities, and it may be that a fire burned through an area that had a lot of arundo, a lot of tamarisk, a lot of eucalyptus, and not only has the fire burned off the exotic vegetation, but it's also opened up the landscape, or maybe even changed the potential use of that land so that it could be recontoured, replanted with native plants. That would provide that kind of lift that would make it a useful certification mitigation or waste discharge mitigation option. There are opportunities in our region to return landscape to its use as habitat. There's a golf course up in the San Tre River Valley that would make excellent mitigation bank. If a fire were to disrupt that acreage and to finally shift the public view towards a mitigation bank, that's an opportunity for us that we would certainly look at. But on a site-by-site project, smaller scale project, as Eric indicated, and as I just described, come and talk with us about those opportunities, and we can see if we can make it work before a lot of money's invested in it and then turn out to be a forlorn hope. There are opportunities, I think, in that type of situation, particularly when you can do some recontouring to expand the banks, and lay them back, and to remove exotic invasives and keep them from coming back. So unfortunately, after fires, the exotic invasives tend to be the fastest ones to return.
Okay, when is CRAM required for proposed mitigation, and when is it not?
We typically require CRAM for most projects. So I'd say most projects require it. I mean,
Right.
Obviously dredging you're not going to require CRAM, but most typical, dredging or fill projects are going to require some type of CRAM.
Okay, and for those of us on the call, probably me, what does CRAM stand for?
Dave, do you want to handle this one?
The California Rapid Assessment Method for evaluating wetlands.
All right, thank you. All right, please explain the ADA compliance process. Why is this part of water quality? Is this documented through the CEQA process?
It's for the documents. We can't post anything that's not ADA compliant on our website. And we've been, as an agency, moving forward to making all our documents ADA accessible. So having, and it's been an issue with when we get applicants and trying to use some of the figures. So our hope is that if we can start getting those submittals ADA compliant when they come in, that we will be able to post them and provide those to the public down the road. So that's the reason for the ADA issue.
Yeah, this is a statutory obligation that was placed on the Water Board and other state agencies that all documents posted on the website have to be ADA compliant, meaning machine readable. A noble cause to make sure that we're as transparent as can be. But what it means is that when we get some complicated drawings and maps, how do you convert that document into machine readable? Now, we'll labor along, and we have contractors converting those documents, but this is an opportunity for the applicant to make things go a little bit faster. For the best reasons in the world, you might be able to make that document ADA compliant a lot faster than we are. We're doing everything we can to comply with the statute and to post ADA documents. Unfortunately, what this is also going to mean is a lot of documents that maybe you or your consultants have used on our website are going to disappear, because we simply cannot bring them up to date in time. We'll have to limit what we post on the website to what is statutorily obligated. And because those are the ones that we can serve and make ADA compliant unless the legislature changes the mandate. So this is strictly an efficiency provision, something that will help make your process go a little bit faster if those documents are easier for us to post, so we don't have to do a lot of forensic work to make the document machine readable. We try to post it on our website. I can post a waiver for 10 days and renew it a couple of times. to allow a document to be posted that's not ADA compliant. We can put an email address and a number saying if you need to have this document after that time period, call us and we'll provide it. There are some workthroughs that we're using, but any place where you have a complicated document, if you can make it ADA compliant for us, that'll make our jobs go a lot faster on the back end of the project.
All right. We're in the home stretch. We got 8 minutes left and we still have questions coming. Thank you very much for your time today. How much weight is given to historic conditions of an impacted water when determining avoidance, minimization, and mitigation requirements? For example, we routinely have properties where a historic water has been channelized decades ago, often predating the Clean Water Act in Port of Cologne, and the San Diego Water Board staff have drawn reference to a historic condition in justifying avoidance and mitigation requirements. In these cases, it's not the current property owners or applicants' responsibility to mitigate impacts that occurred decades ago. Does the Water Board apply the current baseline in justifying avoidance, minimization, and compensatory mitigation requirements?
Yeah, I mean, we do take into account what's been in the past, but really ultimately we're looking at what is existing on the property. I mean, this happens all the time where the project's been graded or whatever, or the developer has developed around it and there's a different type of drainage system going through there, but we evaluate it based off of what's there, mainly there. But we do take into consideration what was there previously, but most often we're looking at what's existing on the property and what functions and services those support.
Has the regional board decided whether any MSCP plans, such as the South County Sub-Area Plan, will be accepted as watershed plans?
I think the question is, because one of the options and the new procedures is if we have an accepted watershed plan, that maybe some of the alternatives analysis isn't required. My understanding is that we were going to get an example of a watershed plan that we could take a look at and get some feedback whether that's acceptable. I don't think we've gotten that yet, so the answer is maybe. So we would like kind of an example, and then we can take and chew on that a little bit and see if that's going to meet our needs.
And for the person that asked the question and everybody out there, this is something that we've talked about with the collaborators at the Water Board offline, and the BIA is looking at presenting something so that Dave and his team can look at it and see if that will work, so you can avoid the alternatives analysis. Okay, were the wetland definition procedures updated this year? I could only find 2019 procedures on the State Water Board's website.
It was adopted last year and then took effect at the end of May this year. So I don't think they've necessarily updated it at this point. So whatever's online is official. And like I said, they just added a checklist and you can go through the procedures. So. Okay.
So if a 401 has been issued already, do we also need a WDR?
No, actually, 401s that we issue are also WDRs. We kind of have a little checkbox there that we include them as waste discharge requirements also. But if we've already issued, there is no need to, unless the material discharge has changed, to reapply. So it should still be valid.
Okay. Yeah, that's true unless you have other discharges that are not associated with wetlands. For example, an on-site waste treatment system that also has to be permitted that may not be covered by our waiver program with one of the counties. But otherwise, for wetlands impacts, it's either one or the other.
All right, what is the best way to amend a 401 permit after it has already been authorized?
That is a good question, and I was talking to my staff the other day, and I need to verify this, that the new procedures don't allow for amendments. That once we issue the certification, that's it. So, and in the past, there's been a pretty simple amendment request process, but I don't know if that's going to take an effect anymore now under the new 401 regs. So that's something I need to verify.
Okay. How is CRAM used throughout the permitting process, and how is it used to guide decisions for mitigation?
It's just another tool to evaluate, both what is being impacted, and then what is the mitigation and how successful the mitigation is going to be after you install it. So it's just a tool that we use. It's not a regulatory requirement necessarily. It's just a tool that we use to evaluate both what is going on the site, and then on the back end how the mitigation is doing.
Okay, I was told by regional board staff that 1-to-1 would only apply to temporary impacts, and that all permanent impacts, even to something like a ditch in a farm field, will be at least 3-to-1. Is this correct?
I don't know who told you that, but that's incorrect. 1-to-1 is, again, you have to meet the no net loss. And the 3-to-1 we come up with is you're compensating for the temporal loss. So you're going to impact a drainage, and your mitigation is not going to come into effect down the road. So we ask for some additional mitigation, whether it's enhancement or rehabilitation or something to make up for that temporal loss. And for temporary impacts, it's 1-to-1. We're not requiring mitigation because you're putting it back, and it's going to be viable within that year period. So we're not requiring any mitigation.
Okay, we've got 2 questions left, and we got 3 minutes. Is there any plan by the regional board to utilize an online portal submission system for applications in the near future? Basically digital.
Yes, and State Board is working on that right now. I know they're working some of the technical issues, but yeah, that would be great, especially something that could kind of easily populate, and we could it would make our jobs a lot easier too. So
all right,
work in progress.
Last question. Can you talk more about the alternatives analysis under the new procedures? How has the initial wave been received by the regional board? Do you have any tips to ensure compliance?
We just started kind of looking at them. The feedback I've got from my staff, it's been fine. It's mainly kind of more of an avoidance and minimization process. But my recommendation is just follow whatever criteria they spell out in the procedures manual. It's pretty detailed. So, and if you have specific questions on whether or not you need to meet them, I suggest you talk to my staff or the staff that you're working with, or just email me the question and I'll get the answer for you.
All right, well, with the last minute, I just wanted to thank both of you for taking the time, not just for the webinar, but for the 15 minutes ahead of time so that we could all make sure that we could be seen and share our slides. I thank all of you that signed up for today. This was the most subscribed webinar to date that the BIA has done this year under COVID. I hope that you found it valuable. And again, you've got Dave and Eric's emails. Send the emails to Eric, not to Dave. If Derek doesn't know the answer, he'll send the email to Dave. And I just thank you both for the collaboration. We enjoy working with you, and I'm hoping that our members will take advantage of meeting with you, calling you to get direction so that they can compress that permit timeline. Thanks everyone for attending today.
Thank you.
Thanks for the opportunity.